take up what we can real briefly while we wait for other members to arrive. But to begin with, we'll call the roll. Roll is open.
Mr. Chair, you have a quorum.
All right. A couple of preliminary matters. First of all, Senator Stewart has Senate Bill 1441. You have a motion on that, Senator Stewart?
Move it be stricken from the docket.
All right. Senator Stewart's moved that the bill be stricken. All in favor of that? Is there a second? It's been moved and seconded. All in favor of that motion signify by saying aye. Aye. All opposed. That bill is stricken. We also have House Bill 1933, Delegate Hope's bill, which is on the docket. It needs to be re-referred to the Committee on Rehabilitation and Social Services. Senator Stewart moves. Senator Howell seconds that motion. All in favor signify by saying aye. All opposed. That bill is re-referred. Next, we have on your desk, we have a list of House bills with which are cognates, have identical Senate bills. It looks like 4 of those House bills passed unanimously out of committee and out of the Senate. House Bill 1712, Delegate Herrings. House Bill 1909 from Delegate Leftwich. House Bill 1940, Delegate Rob Bell's. House Bill 2665, Delegate Stolley's bill. Those would be before us in the block if somebody wants to make a motion in the block to report those bills out.
So moved.
All right, it's been moved and seconded that those bills be reported. The roll is open.
Ayes 10, no 0.
All right, those bills are reported. We also have House Bill 1767, Delegate Jones's bill, which is almost identical to Senator Surville's bill dealing with wrongful death beneficiaries. I think what we ought to do is conform that to Senator Surville's bill, unless the delegate has any objection to that.
I have no objection to that, Senator.
All right, is there a motion?
So moved.
All right, the motion is to conform the bill and report it.
Report it.
Second? It's been moved and seconded. All roll is open.
Ayes 10, no 0.
It's your easiest trip to the Senate Courts of Justice Committee ever.
I'll take it.
All right, at this point, we have a number of other bills. What we're going to do is suspend for a minute while we try to get more members here. And if anybody wants to, needs to leave a proxy, this would be a good time to do that.
Can y'all hear me? Yes, you can now. Delegate Thomas, you've got a couple bills I notice. You're on the sign-up sheet, which don't appear to be terribly controversial. Which one would you like to start with? All right, House Bill 2136.
House Bill 2136 would provide that in any criminal case, an accident reconstruction expert, when properly qualified, may testify as an expert witness in the court of law, subject to the rules of the Supreme Court. So the reason the bill is in front of you, I had a bill last year relating to drones and this expert data that would be available, and I found out that Virginia is the only state that doesn't actually permit that in a criminal case. And the Commonwealth's attorney in the city of Fredericksburg created a briefing book on that. And it really started with a court case back in the 60s where they hinted that maybe it wasn't advisable or admissible. And then over time, case law, now it's pretty much the default. They don't even look at this data that could be available for both sides to really get a true and accurate result. So that's why the bill's in front of you. If you need anything on the history of that, the Commonwealth's attorney is here as well.
Let me try this. Is there any opposition to this bill?
Yeah, hold on.
All right.
Let's slow down the train
Senator
here.
Peterson he started first. Go ahead, Senator
Yes,
Peterson.
sir. I've tried, well, first of all, accident reconstruction experts definitely cannot be used in civil cases. Am I correct? Yes. Thank you. I'll take that as a yes. Y'all keep looking at each other. So why would we allow it in a criminal case when we have a higher standard of proof if we don't allow it in a civil case?
Mr. Chairman, of course, we're not asking that the expert testify on the ultimate issue in fact, but to provide facts for the finder of fact. And I don't know. I mean, I think the rules of evidence talk about experts properly qualified in civil cases.
I've had this situation before, and I've had motions in limine. I've been on both sides of this issue. You cannot, in a personal injury case, you try and put on an accident reconstruction expert who's a, quote, engineer. You could put as many letters after their name as you want. It's not going to come into evidence.
Well, of course, our specialty is criminal law.
I understand that, ma'am. And I'm telling you that you say it's not the ultimate issue of fact, but if you put somebody on that's going to take a crime scene and say, well, this...
Senator Peterson, would you ask the witness a question rather than giving her a lecture, please?
Wouldn't that be prejudicial to a defendant?
Mr. Chairman, it would not be prejudicial to a defendant because we're not limiting it to the Commonwealth having experts, but certainly this expert would help both the defendant potentially and the Commonwealth.
Further question, Mr. Chair?
Senator Peterson.
Who's going to pay for the expert for the defense?
Mr. Chairman, it depends on, if the defendant is indigent, I think that the Supreme Court would pay for it, just as any expert under AIC.
Does that help you?
It doesn't help me, but I appreciate the answer.
You just don't like it, okay.
I don't like the bill.
Senator Peake, you have questions? All right. Mr. Benjamin, I had a question. I thought you could use a reconstruction expert in a civil case if that individual was properly qualified in court.
Mr. Chairman, I just don't know. I don't know of a prohibition against it in criminal cases, but it's been a long time since I've taken a look at the case law.
Civil cases.
Oh, in civil cases, I absolutely don't know anything about civil cases.
And I thought you could already use it in criminal cases as well if they were properly qualified before the court.
Mr. Chairman, the latest case, and I sent every member of the committee a synopsis about this because I thought it was coming up after crossover. But the latest case was in 2017, and there was a blanket statement by the Court of Appeals that accident reconstruction experts' testimony is not allowed in criminal cases. And that is a misstatement of the original case in 1966, which is Grasney, which said that an expert couldn't testify to particular parts in a case. So the language has morphed over the years to mean that we cannot have an expert. They're totally excluded, whereas that wasn't the intent in 1966. And in addition, since 1966, there are organizations that qualify accident reconstruction experts. So that there's better data, there's better analysis of the data. So it will be helpful to either side. Of course, they still cannot testify to the ultimate issue in fact.
Right.
Mr. Chairman, I guess my concern is this. Look, if we were to look at this bill and substitute the words bite mark testimony for accident reconstruction expert, I think many of us would understand the problem there. It's one thing to qualify as an expert. You can do that simply because of your experience in reconstructing accidents. But qualifying as an expert and being allowed to give an opinion doesn't mean that you are using valid techniques or methodology. And so the unintended consequence of this, I'm concerned, is permitting what we would sometimes call junk science to be admitted in a criminal case. And I know the patron doesn't intend that, but that's my concern.
Mr. Chairman, a black box data is not junk science. And as well, the National Highway and Traffic Safety Administration has sanctioned expert accident reconstruction experts. So, and that's happened in the last 2 decades. And additionally, every single state in the United States allows accident reconstruction in criminal cases. That Virginia is the last one is amazing to me.
Mr. Chairman,
Senator Obenshain.
I have some sympathy for the patron and Ms. Jenkins on this. I just wonder whether this is the right way to do this. I mean, I do believe that we have some serious issues with respect to getting expert testimony in civil or criminal cases. And I think that we really need to seriously look at this issue. You know, I don't know that this does a lot of harm, but you know, I'm just wonder whether A, it's necessary, and B, whether this is the right way to tackle the larger issue that I think this bill identifies.
Mr. Chairman, I would say that just in Fredericksburg in the last year, there was an accident involving a tractor trailer running over something like a Ford Metro and killing 2 people. We were not able, with the evidence that we were able to present, we weren't able to tell what happened. Of course, we couldn't hire an accident reconstruction person because we couldn't justify the expense if we couldn't use that evidence. So I think that scenario repeats itself over and over in many, many jurisdictions in Virginia.
I would like to add, the original language that was filed was very prescriptive. It talked about in only cases of death and serious bodily injury. We worked this over with the courts committee on the other side as well. And what we found was there were other areas of expertise where they had to specifically say in a very broad way that this is admissible to get the courts to recognize that. But it leaves it very broad because the judge still has, you know, the ultimate authority to determine if the person in front of them is truly qualified. So that's why we kind of removed all the prescriptive language and put it in this section, because this section has been used before to do that for other professions.
Right, I want to ask a question from the other side. So if I've got a DUI manslaughter case, and it was because 2 people collided and one was killed and the driver had been drinking, you're telling me that under the law today, I can't hire a reconstruction expert to testify on behalf of the defendant?
That's what the case law says.
And that I need this bill in order to be able to do that?
Mr. Chairman, Senator Stewart, the way we would handle that, if it were a defense issue, is we would hire the expert, we would proffer his testimony, what it would be, and if the ruling was that he could not testify, then it would become an appellate issue, and we would then take it up with the appellate court. And that is how these areas are typically resolved is on appeal. And it sounds like that's the problem right now is that a court has misinterpreted prior precedent. But the
Senator
orderly way to
Obenshain.
do this is by appeal.
Senator Obenshain.
I think there are a couple of things I am interested in. Number one is whether this ought to be limited to criminal cases. Number two is whether this somehow by saying when properly qualified, the expert can testify, maybe opens too broadly the scope of the testimony that's going to be allowed. Maybe not too broadly. Maybe it's great. I don't know. But I'm going to move that we pass this by for the week so that we can talk about some of these issues.
All right, without objection, the bill will go by for the week.
Can you take it back over?
I'll take it back over.
Take it back over.
Senator Barker. I'm sorry, Delegate. I hope we picked your bills because we thought they were easy bills today that we could slide right in and right out. And apparently we did a poor job on the first one, so hopefully the second one's can be a little bit easier.
Let me see if I can bat 500 here for you, Mr. Chairman. House Bill 2138. So this bill would add a couple of items to the list of noxious chemicals. Currently, chlorinated hydrocarbons are on that list. As these products change.
Are you aware of any opposition to this bill?
I'm
Is this
not.
bill, any problems with this bill, Charles?
No problems, Mr. Chairman.
Anybody here testify in opposition to this bill? Is there a motion on this bill? It's been moved and seconded the bill be reported. Roll is open. Is that better?
Thank you.
All right. Senator Barker.
That's 14-0.
Thank you, Mr. Chairman, members of the committee. I have Senate Bill 1302, and there is a substitute for that bill.
Substitute's been moved and seconded. All in favor of adopting substitute signify by saying aye. Aye. All opposed. Substitute is before us. Senator Barker.
Yes, Mr. Chairman, this bill deals with the ADA provisions, People with Americans with Disabilities Act, and standards for that related to websites that are available to the public that can be used, and how we ensure that that the people who have disabilities have access to the content on those websites, but also how we deal with situations where, because of lack of federal regulations and guidance on these websites, what should be available in a website, that we put in a provision to inoculate the credit unions and community banks, which have been subject to significant payments and costs incurred as a result of out-of-state law firm demand letters threatening lawsuits because the financial institution is allegedly in non-compliance. And so what we're trying to do is to do a temporary patch to be able to protect credit unions and community banks who have not complied with a standard, because there is no standard that's been adopted at the federal level right now. The situation has been that there have been a number of institutions that have paid $10,000 to out-of-state law firms just to get them to agree not to file anything. In reality, it wasn't clear that they actually had a client in Virginia who was affected by this, and so in many instances it appears to have been more like an extortion letter than anything else. There are 5 or 6 cases that have gone to court in Virginia, and in each instance the financial institution has prevailed, but in many instances they've incurred legal costs of $50,000 or more to be able to defend themselves. So what this does is attempts, and we've made numerous changes to the bill. It's a fairly short bill, but we've actually made numerous changes. And I certainly appreciate working with the staff for the Virginia Board for People with Disabilities and some of the other advocacy groups for people with disabilities to improve it. Not everybody is happy. Some will testify in opposition to this bill, but there are others who we've worked with that have not taken a position either in favor or opposed to it, because I think we've worked very hard to address their concerns. What this does is in sections B and C of the bill, which is in lines 13 through 24, is set up a process whereby for 1 year, but for 1 year only, so that there's an enactment clause on lines 29 and 30 that has sections B and C expire as of July 1 or June 30th, July 1, 2020. For 1 year, if someone files a suit regarding these website situations, and in reality, there haven't been that many suits that have prevailed, but there's been several that have filed or threatened to be filed, and so it's not that they've been a lot of suits that have been successful. For 1 year, basically, you file your case, and the entity that against which the case is filed has 120 days in which to file a response under, as is shown in line 15, in compliance with Rule 3:8 of the Supreme Court. This extended to 120 days in these situations. And they must provide, in the suit, they must provide an explicit indication of why and how the website is not compliant, so that they have an opportunity to correct that.
Mr. Chair,
And
Senator Peterson.
can I just break in, and I understand you're
Sure.
on a roll, but this is a violation of the Americans with Disabilities Act, correct?
that's correct.
That's a federal statute.
That's correct.
And a federal remedy.
That's correct.
How do we limit somebody's federal remedy by changing our state law?
What we do is, in many instances, in some instances anyway, they file simultaneously in both federal and state court, so this would provide some protection in state court. In other instances, when there are situations like this, if they're filing in federal court, the federal court may take some recognition of what the state law is as it relates to this
Further question,
process.
Mr. Chair?
Senator Peterson.
Have we ever had a situation where we've taken a federal cause of action and changed our own state procedures to do that?
Mr. Chairman, Senator Peterson, I have no idea whether we've done that, but so I
Just
can't.
just to give you some idea as to,
Right.
some of the discussions going on, and I do want to hear from supporters and opponents,
Right.
but, here's one concern I've got is, we're taking one class of lawsuit, one claim, and frankly, not a very common claim at that,
Right.
and are crafting a separate civil defensive framework for that one certain kind of lawsuit, embedding it in the code. And, I'm not aware that we've ever done that before. And if we start doing that, I'm concerned that, we're going to have 100 different defensive statutory schemes embedded in the code in the future in order to deal with cases that courts ought to be dealing with under their inherent authority to award sanctions or to manage their dockets. So I think I share some of Senator Peterson's concerns, and just toss that out to you as you
Certainly.
continue to address the bill.
Yes.
And so,
All right, well, certainly, I understand your concern there on this in terms of setting this precedent and sort of setting up a separate process here.
and I
However,
did share that,
Yes.
my concerns with some of your
Yes, I'm aware.
principles.
Yes, yes. The provisions of sections B and C would be in place for only 1 year. So it's basically buying 1 year of protection against some of these basically frivolous letters and and potentially actions that might otherwise occur. What it also does in Section D, however, is it provides clear guidance to the financial institutions as to what standard they need to comply with. Part of the problem they've had is that there is no federal standard or even guidelines at the federal level as to how to proceed. And so consequently, it's not as if they've not been complying with something that is already specified out there. It's that there's nothing specified for them to comply with. And what this does is identifies in on lines 27 and 28 what's known as the Web Content Accessibility Guidelines 2.0 Level AA as developed by the Web Accessibility Initiative. This provides the guidance that tells them if you meet this, then from a Virginia perspective at least, that this is the standard that must be met. And the clarifying, or the companion language, the limiting language to this is on lines 25 and 26, that basically says that until such time as the federal government adopts standards governing website accessibility, that's what our standard will be in Virginia. So it does provide an opportunity for the financial institutions to know what standards they have to meet, and for the courts then to be able to, look at whether they've met those standards. As I said, part of the problem has been that we're getting people filing you pay us $10,000 and we won't file that lawsuit we were going to file, and people complying with that when there was no evidence that there was any issue there. But secondly, it deals with the problem that the financial institutions have had in that there is no standard. And so it's not as if they've not been meeting an adopted standard, it's that there is no standard, and this at least gives them that as well. And what this would do, I think, in most instances, is provide some protection for the financial institutions for that 1 year from these attempts to file suits, but then would also put them in a position where they have 1 year to meet these guidelines, and they lose all that protection come July 1 of 2020. And I think that in reality, this will actually provide more assistance to people who are deaf, hard of hearing, or are visually impaired, because this will ensure that most financial institutions, if not all, will meet these standards by July 1 of 2020, absent this, absent any standard that is existing in Virginia, and absent protections against some of these frivolous suits. My guess is that there will still be a significant number of institutions that would not meet these requirements by July of 2020.
All right, anybody on the committee have any questions of Patron Center? Hal?
Thank you, Mr. Chairman. My aide informs me, because I'm never in my office enough to meet with people, that virtually every disability group was opposed to your initial bill.
That is correct.
And what I'm curious about is this substitute, do they like the substitute, or do they still dislike this?
It's a mixed response right now. There clearly are some who did not like the bill, who still don't like the bill. They basically said they don't want any protection for these financial institutions, et cetera, here. There are others who have worked collaboratively with us and are pleased that with the progress and steps we've made on this, and are not taking a position either for or against the bill. So,
I got to go up and present my bill.
Senator Barker,
yes.
I'm trying to understand this. So on line 27, you said if it meets the Web Content Accessibility Guidelines 2.0 level AAA. Is that law somewhere now?
No, it is not law.
Is that guidance somewhere?
It's guidance. It's published guidance,
All right,
but it's been developed by people who do develop websites or those types of things. So it's really some
Where's
coming
that
from
guidance
that
come from?
It basically comes from people who are involved in trying to ensure that there's what type of standards they would want to be in place. The problem is that these standards have not been adopted by the federal government and are also not referenced in our code right now.
So
the
these
federal government has not done anything, so this is an attempt to try to say, at least for Virginia,
Mr.
we're going
Chair.
to do this.
All right, so
till it's
they've not
addressed.
adopted these guidelines. Is that what I understood you to say?
Yeah, and that's been part of the frustration, because the financial institutions don't know what guidelines or what requirements they are supposed to meet.
All right, Senator Peters.
I was just going to say, I mean, what prevents you from picking up the phone and calling one of our 11 representatives in Congress and asking them to change this? Why are you coming to us about it?
I think
I think
that's
the
a
phone was
question.
answering.
Yeah.
I think that's a question, Senator
Yeah,
Barker.
that's that is a question, and obviously, that could be done. What I think the frustration that a lot of people, and this is frustration from the people in disability community, as well as frustration from some of the businesses and financial institutions that deal with this issue, they would like the federal government to provide clarity, and the federal government has discussed it, but has not come forward to do it. And so out of frustration, and particularly given, the actions that have been taken against some of their companies, they've asked us to at least try to set a mark here in Virginia as to what the requirement standard would be, and secondly, to be able to provide a little bit of protection for them for a short period of time as they transition into this.
All right, let's see if there are people here who'd like to speak in favor of this. Are there those that would like to speak in favor? Please come on up, and we are timed on this, so everybody's got 3 minutes each side.
Good, thank you. And I want to thank Senator Barker for working with this. Not an easy issue. This is, you would be amazed to know how rampant this problem is nationally. It's a little cottage industry has developed in California where certain law firms send out demand letters to financial institutions. Usually the first thing the financial institution does is to call their insurance carrier. The insurance carrier says settle. It's cheaper to settle than to contest it. And the fee, which is essentially an extortionist payment, is $10,000. Pay us $10,000 and we'll go away. The 5 cases in Virginia that we know of, federal cases, have all been thrown out for lack of standing. Each of those cases, however, the financial institution said, no, we're not going to pay this extortion payment. We are going to go to court. And that's where they can concur, in some cases have concurred significant legal expenses. So it is a national problem to the extent that one trade association, credit unions, I can't speak for the bankers, were sent a model legislation for various states to use. We worked on that model legislation, which frankly really wasn't very good, wasn't really a model to Virginia. We got a much better product. We let the disability community know back in November that this was coming, wanted their cooperation. We have probably given, to answer the question from Senator Howell, we probably have given in 70% to the disability community that they are still not satisfied, and I think that you will hear from them. To Senator Peterson's question, the trade associations in Washington have begged the Department of Justice to give some guidance on whether the ADA public accommodation section applies to website accessibility. We've got no guidance. And most people think that we're not going to get any guidance from DOJ through the current administration in Washington, which again sort of accentuates the problem. Senator Barker has attempted, and we know it is a bit unusual. This General Assembly has trying to address a federal problem on a state level with the patent legislation and trolling statute several years ago. That may be a bit different, but it had the same, it was trying to address a widespread problem nationally. So I would just urge, and
I don't mean to interrupt you, but if you could.
yeah, I would just say, please don't let perfect be the enemy of good. Senator Bark has insisted that this lapse after 1 year. We think that's reasonable, and that the financial institutions will go ahead and meet that international standard. The website guideline 2.0 was formed in 1997 when the internet came online, about how it can be accessible to all folks. So it's internationally recognized, that standard.
All right.
Thank you.
Anyone else? We're out of time, but if you'd like to register your support.
Mr. Chairman, members of the committee, Matt Bruni on the Virginia Bankers Association. Want to associate our remarks with remarks from Mr. Clemens. We and the credit unions are standing together on this. A number of our community banks throughout Virginia have received these demand letters, have received suits under this, and without clear guidance from the Department of Justice at the federal level, we think this is a good step in the right direction to thwart those efforts.
All right, thank you. Are there those that have a contrary opinion that are opposed to this that would like to speak? Please come on up. They are. Yeah. Yeah. The bankers, this is for the bank. Okay. It's like the patent troll thing I did.
Good afternoon. My name is Maureen Hollowell, and I'm representing the Virginia Association of Centers for Independent Living. I live in Virginia Beach, and I have an adult daughter who is deaf. Senate Bill 1302 would establish obstacles to people with disabilities who try to use these websites. The bill impacts proactive action and compliance. The financial institutions would not be compelled to comply unless a complaint is filed. Senate Bill 1302 will make it more difficult for people to use websites at a time where all of us are using websites more and more, especially with financial institutions. Proponents of the bill have raised concerns about the misuse of disability rights by attorneys who are leveraging these fees. The courts and the state bar should be dealing with these problems in ways that would not diminish the access for people with disabilities, even for a year. The bill will result in delayed access, and it will increase the frustration and the required compliance now. The Americans with Disabilities Act was passed 29 years ago.
Thank you. Yes, sir. Please come up.
Good afternoon, Mr. Chairman, members
Good
of the
afternoon.
committee. My name is Mark Roan, and I'm a member and serve as the treasurer of the National Federation of the Blind of Virginia, which is the oldest and largest organization of blind people in the Commonwealth. And while I'm here to speak on behalf of our organization today, last Tuesday we had more than 50 of our members from across the Commonwealth come and address the offices of all the legislators here at the General Assembly as to our opposition to this bill. As all the members of the committee are aware, financial institutions are requiring more and more of their clients to perform their financial business themselves online. We as an organization applaud that. We like to take control of our personal activity, and we want to do that. And in most of the cases today, we're able to do that. Most web developers today are following guidelines, and you've heard that there are not adopted guidelines, but there are guidelines out there, and most website developers are using those, and we do have access to financial websites and are happy to be doing that. Our concern with this bill is that if you do pass this, you're going to be giving the message that these guidelines don't need to be adhered to whatsoever, and that the institutions that are hiring them don't need to pay any attention to existing disability law. Thank you for your time.
Thank you. Yes, ma'am.
Good afternoon, Chairman, members of the committee. My name is Jenny Halborn. I represent the Disability Law Center of Virginia. We wanted to come before you and urge you to oppose the bill today for most of the reasons already stated, but also to echo Senator Peterson's comments that this gives credit unions the false sense that they don't need to do anything until they are sued, when in reality, an individual can still file under the ADA. And in the federal rules of civil procedures. And in the meantime, people with disabilities across Virginia are being denied these services that are online. As members before said, that, you know, as we move into more technology age, when more and more transactions are occurring online, thousands of Virginians won't be able to access these services. So we're willing to work with the patron and the credit unions in the meantime to fix the bill, but we urge you to oppose for now.
Okay.
Thank you.
Senator Barker, you want to add anything?
Yeah, sure. Let me just wrap it up. In reality, the bill does not basically exempt them from legal action during this one-year period. All it does is it says that if a suit is filed in court during this, before July 1 of 2020, that they have 120 days to respond to the suit, so that they have a time period in which to address any issues that are raised with their website during that time period. It still allows, even if the suit is dismissed because they've complied with it, the plaintiffs to seek attorney's fees. So there is opportunity for, you know, for continuing to pursue that. So it is a very limited protection of the finance that the finance institutions have. It is only, you know, extending from 30 days as a minimum up to 120 days on the response to be made there. And they all have to meet it by July 1 of 2020, or there's no protection whatsoever in this bill because sections B and C go away. What it also does is it ensures that they are, that going forward, all the financial institutions are meeting website accessibility 2.0 AA standards, which are the standards that are most applicable to them. So, and that was worked out with the various parties here as to what standard they would have to meet, so that they are meeting the standards. And my strong assumption is that with this bill, you will have everybody meeting these standards by July of 2020. Without this bill, you won't. So.
And Senator Barker, Mr. Clement mentioned the patent troll issue we had. I carried that legislation, and it was a tough one. We took a little different approach, as I recall.
Yes, it was a little different approach, but it was similar in terms of the issue here.
But seems to have helped a great deal with that issue. All right, Mr. Benjamin, do you have any observations on this?
Mr. Chairman, one thing that struck me is that I'm not certain that anywhere else in the code we have a provision that says that a person or an entity is in compliance with the applicable law if they do something. And furthering that thought, I looked at what's referenced in line 27, the web content accessibility guidelines. I'm sure everybody who has a stake in this knows where to find those, but I wouldn't have a clue where to find those. And so I wondered if that is the goal, why we weren't simply enacting those guidelines as law and saying that entities shall comply with these guidelines. That would be a more direct approach than simply saying when somebody is in compliance with the law, because that's unfamiliar to us in the code.
I would have no problem stating exactly what you said there. So I think that saying that this is the standard until and unless the federal government comes up with a different standard.
Mr.
And
I think
that
what
applies, so.
I think he's suggesting your bill be amended to just say,
Yes.
number 20, the line 27 is a law in Virginia, and
Yes.
eliminating everything else. You didn't want to do that?
I would prefer not to do B and, not eliminate B and C. I would prefer, let's put it this way, I would prefer to have B and C, but with a D amended.
Senator Chafin wanted to speak on this as well.
So, Mr. Chairman, as introduced, the bill here today, I feel like it's a step in the right direction, that the credit unions and the banks are looking at trying to navigate these waters and an effort to get in full compliance, quite honestly. And I applaud the efforts of the patron in wanting to move this bill forward and setting up a framework in which to do that when the regulations aren't very clear in terms of what exactly puts the banks and the credit unions in full compliance. So as it is introduced, I'm prepared to make a motion to report the bill.
Is that a motion?
That is a motion.
All right, is there a second?
I'll make a substitute motion. If we don't have a second. Did you have a second?
I don't have a second on the primary motion to report the bill. Unless anybody else wants to make a second. Motion to report by Senator Chafin. Motion properly seconded to report the bill. You don't want your substitute?
I'm gonna make a substitute motion.
Senator Peterson.
And I apologize to Senator Barker. I did want to approach him, but I don't like this bill for a couple reasons. Not that I don't understand the problem, but this is a federal statute, and we're trying to limit a federal remedy. Normally, these cases would be filed in federal court. I've never seen a law that we pass where we actually tell somebody, because of your remedy, you get a different set of rules in our court. And I'm very uncomfortable with that. I feel like we're treating some people differently than others by doing that. Secondly, we're trying to determine here how a website should comply with a certain standard. I don't have that knowledge. I wonder if any of us does. Again, this is a federal law. It really ought to be decided by the federal government. And I just don't think this is ready for prime time, so I would move to PBI, if I can get a second.
There is a motion, substitute motion properly seconded to pass the bill by indefinitely. Please open the roll. They're trickling in, Senator Barker.
Ayes 7, noes 5, abstentions 3.
Thank you, Mr. Chair.
Thank you, Senator Barker. Always good to see you. Let's see, Senator McClellan here. She is not here. She's next on the sign-up list. Senator Eben.
Thank you, Mr. Chairman. This is Senate Bill 1736.
All right, Senate Bill 1736.
What this deals with is a relatively new phenomenon called deep fake. And what a deep fake is now, thanks to artificial intelligence and large photo libraries on the internet through Facebook, Instagram, and other places, and large libraries of explicit material online, it's not hard at all to create convincing reproductions of a person engaged in sexually explicit acts when such action never occurred. And we know that there's tools exist on Google's artificial intelligence library that are free and publicly available. We also know that you can get one of these for about $20. You can order one. And, once it's on the internet, it's there forever. And video in the past has served as a benchmark for authenticity because it was too technically complicated for anyone to get it right. And it really can lead to horrible consequences for personal relationships, for marriages, for jobs, for careers, and can follow a victim for a lifetime. So what I'm proposing is that we update what we call the revenge porn statute that was created in 2014 to address this problem of defamatory and obscene portrayals. That's the genesis of the bill. I didn't know about this phenomenon until December 30th when I read about it in my local newspaper. And it's really horrifying to think that for $20 you can ruin a young woman's or person's career and maybe a marriage or relationships, their friendships and so forth. So that's the nucleus of the bill.
Okay, any questions of the patron on Senate Bill 1736? Do you have anybody who'd like to speak in favor of this?
I do not.
All right, is there anyone who'd like to speak in opposition? Anybody paying attention to this bill?
I am, sir.
I know you are. Senator Benjamin, Mr. Benjamin, you have any thoughts on this? I don't know why I do that. Mr. Benjamin, Lawyer Benjamin, Attorney Benjamin, do you have any thoughts on this?
Mr. Chairman, I think it's okay. The only issue that it potentially arises is a free speech First Amendment issue, but I think that is dealt with by the intent that is required. And so if you do something with the intent to coerce or intimidate, it's not protected speech. So I think it's okay. The only thing that concerned me a little bit were the words "or appears" on line 14. And I didn't know if that, and I still don't know, if that broadens this beyond what the patron intends to reach, but I'm okay with it.
Well, I assume you're trying to get to somebody who makes something that's kind of fuzzy, but it looks like they're nude. But I have the same question in my mind.
You know, you could take a photograph of somebody on the beach, and just because of the angle, you might be violating this provision, except I keep coming back to the intent that's required for it to be a crime, yeah. So if you're maliciously doing it to coerce somebody, I think the bill is okay.
And keep in mind, it does say falsely created image. And using language that's already there, as Mr. Benjamin said, for the malicious dissemination.
Well, see, Mr. Chairman, I understand that "or appears," right now you're tying it up with the falsely created image, but the words "or appears" would also modify the existing language.
Okay, well, I mean, the idea is that they are portrayed as naked, whether or not they're. I have a question with the existing statute, which I just was noticing, where it said totally nude. I mean, do you have to be totally nude to engage in a certain acts or portrayed to? But that's the existing code.
Mr. Chairman, to answer the patron, the language goes on to say, "or in a state of undress, so as to expose private parts." I'm just a little concerned about including the word "or appears." I
see.
It's
Okay.
just,
That's not essential for the bill.
All right, line 14, "or appears to be." Is there a second to that amendment? Motion properly seconded to make that amendment. All in favor, please say aye. Aye. Opposed, no. The ayes have it. Okay. Is there a motion on the bill? Motion properly seconded to report the bill. I don't think this has to go to finance.
The financial impact statement I got said it did not need a budget amendment, though I did file one.
Okay. Please open the roll.
Thank you.
Ayes 15-0.
Thanks.
Senator Cosgrove.
Hello, Mr. Chairman.
Good afternoon.
Yes, there it is.
And you?
I have Senate Bill 1050 for you today.
1050?
Yes,
Okay.
1050. I see my friend Senator Norman is here to back me up. Mr. Chairman, Senate Bill 1050, the purpose is to amend 19.2-245 with one sentence, and that's, as you can see in the bill, notwithstanding the provisions of this code, the prosecution for a violation of this article may also be in any city or county or city in which the issuer, acquirer, or account holder sustained a financial loss as a result of the offense. What we have is a forgery bill here because mobile deposited checks are being used more and more frequently. In Chesapeake, the economic crimes investigators see between 10 to 15 cases a month that involve mobile deposits. Currently, they're working on embezzlement of approximately $40,000, where some of the money's been taken by forging 3 checks and mobily depositing them. They have not been able to get geographic data for mobile deposited checks from any major bank or credit union except USAA. They've not been able to get IP addresses for mobile deposits that were done through residential routers in most cases. Basically, Mr. Chairman, what this would do would allow the localities to take action in the city or county if they could not find the IP address or the locality where the forgery was perpetrated.
So where the account holder lives?
Yes, sir.
Okay. Any questions of the patron? You have anybody who'd like to speak for?
I don't think I have anybody here.
Any opposition?
I'd move to report, sir.
Second, yeah.
Can I just let her speak? Apparently,
I'm
Commonwealth
sorry.
attorneys are opposed
Sorry, I
to
didn't
it.
see her.
Ms. Jenkins, come on up.
Mr. Chairman, the Commonwealth's attorneys are not opposed to it, but we would suggest a change of language in the last sentence. And we would just ask that it refer to an individual or entity.
On line 16,
Yes, on line 16, where an individual or entity sustained a financial loss. The one on the other side says where a person, which we don't think is appropriate either, but individual or entity does cover, I think, all that we need to cover.
issue require account holder.
Definition of person.
Mr. Chairman.
Is that as comprehensive, Charles?
Right, just for, a person does include individuals or entities, so if the amendment was to be made, it would be changed to person.
See, I have where insurer or acquire is there. This is the first I've heard of the change from the Commonwealth's attorney. This is actually brought to me by our Commonwealth's attorney.
I think it does. I think it broadens
I
it, yeah.
know Nancy very well.
Right. It doesn't cause it, you know, foreseeability and causation. It's not just the account holder.
Report
Yeah,
it
it's
as
not
it
just
is.
the account holder or the issuer.
Yeah.
It's any person who's.
Individual or entity would cover.
Mr. Chairman, we're just talking right here.
I think there's more comfort with
Yep.
your bill as it is, Senator.
Yes.
Castro, without any amendments
I'm very
today.
respectful, excuse me, sir, I'm sorry.
No, Senator Norman.
Very respectful. I'm always suspect when we start tweaking words on the fly like this, and sometimes they, in spite of the best intentions, there are unintended consequences, and I would feel more comfortable reporting the bill as it was presented, and perhaps Senator Cosgrove could talk with the Commonwealth attorneys and really give some thought. I'm concerned, just my intuitive reaction is we're broadening it, and I'm not sure that's a good thing.
Is there a second to that motion to report the bill as is? Motion properly seconded to report the bill. Please open the roll. Is that all you have, Senator?
Yes,
Ayes
that's it.
14-0.
Thank you.
Thank you, Mr. Chairman, members of the committee.
Senator Favola, I don't see. Senator Cosgrove, I'm told you have another bill on the docket.
1721.
That's something, you want to strike it quickly or something? No, I'm kidding.
He only gets to bat 500, right?
Yeah, Mr. Chairman. 1721, you'll have to forgive me, I have to pull it up real quick. My bad. It's probably something I want to strike anyway. 1721.
You have a copy of the bill to give him?
Mr. Chairman, that is Senator Cosgrove's Charitable Gaming,
Oh, yes.
Electronic Gaming Devices Act bill.
Yes, Mr. Chairman, what I wanted to do, that was actually referred to courts. I want to strike that bill, and actually, I take that back. I want to have my bill rolled into Senator Reeves' gambling bill.
Okay.
I
What
apologize
number?
for the confusion.
That would be,
1738.
Mr. Chairman, that would be Senate Bill 1738.
1721
you wanna
into
pick that up real quick?
1738. All right, we can take that action now. Is there a motion? Motion properly seconded to roll his bill into 1738. Please open the roll. All right, thank you, Senator
Thank you, Mr.
Cosgrove.
Chairman. I apologize for the confusion.
Ayes 14-0.
Looks like we got Senator Mason or Delegate Price. Delegate Price is actually next, Senator Mason, so
We were just betting on
just keep your seat. Delegate Price, what bill do you have?
Yes, I have House Bill 1998.
House Bill 1998.
You can start getting them.
All right, tell us about your bill.
Sure, thank you, Mr. Chairman and members of the committee. Currently, a public safety official, healthcare professional, or school board employee, if they are exposed to bodily fluids in the normal course of their jobs, most individuals voluntarily consent to a specimen being tested. In the rare instance the consent is not obtained, the courts can compel an individual to give a specimen to test for hepatitis B, hepatitis C, and HIV. The issue that came to our attention is the amount of time it can take for a hearing, while the person who has been exposed must start preventative treatments without knowing exactly what they were exposed to. Being passed out right now is a news article about the story of Hampton police officer Laura McLean and the 10 days that she waited for a hearing. The preventive measures she had to take, not knowing what she may have been exposed to, were costly and actually caused her to miss work, not to mention the trauma of living in the unknown until her test results came back. So last year I brought before you a bill that had passed the House and attempted to achieve a solution to this wait time, and it was met with concerns from this committee, and I would like to thank the committee and staff for working with us in the interim to reach another solution. So we took your concerns to heart, and House Bill 1998 would expedite such a hearing to occur within 48 hours of the filing of the petition. It does not involve magistrates, and it would stay in the GDC but be advanced on the docket. And this will help the individual who is exposed and their healthcare provider know if they need to take more aggressive measures or not. And there is an added section M that clearly states that the test results can be used for no other purpose. Mr. Chairman and members of the committee, this is supported by the Hampton Police Department, the Newport News Police Department, and the Virginia Nurses Association.
Thank you, Delegate Price. I note that you did have this bill last year and took the time to work on it this year and made substantial changes to it. Any questions of Delegate Price on this? Senator Norman, excuse me. Do you have an amendment on this?
The only thing we were going to add, Mr. Chairman, is on line 331. Instead of referencing the next day that is not a Saturday, Sunday, and so on, we would amend it to say on the next day that the court is in session.
I'm amenable to that, absolutely.
Friendly amendment. Senator Norman moves and Senator House seconds the amendment. All in favor, please say aye. Aye. Opposed, no. Ayes have it. Do you have anyone who'd like to speak in support?
If there are questions, I do have someone with Hampton City.
Anybody in opposition to this?
Can I just ask a question, Mr. Chair?
Absolutely, Senator Peterson.
And I apologize, Delegate, but I just got here late, but I do kind of remember this from last year. So the idea is if someone is exposed to HIV or Hep C or some other potentially communicable disease, that there's an order entered requiring testing of whom is being tested.
So this is in a situation where the person that works for a public safety, healthcare professional, or school board employee is exposed to someone else's bodily fluids in the course of their job. So this is to, if the person whose bodily fluids they were exposed to refuses to offer up a sample to be tested. Instead of just waiting until the GDC gets to the case, this would expedite their case on the docket.
Okay, further question, Mr.
Senator
Chair?
Peterson.
if the person refuses to give the sample, are they compelled to give the sample or physically compelled? What happens?
Yes, so that's already law. What
Okay.
we're trying to do is, instead of them waiting until the GDC gets to the case, mandate that it must be within a certain time frame from when the petition is filed. So we're not changing how it's happening, we're changing the time frame of when the case could be heard.
And that's the 48 hours.
Exactly. And that is not an arbitrary number, Mr. Chairman. That is a number, the 48 hours, because typically that is the time that is needed for prophylactic treatment to begin in order to potentially save a life of the employee or worker.
Okay.
Okay. Any other questions?
I would move to report as amended.
Second.
Motion properly seconded to report the bill. Please open the roll. Thank you,
13-0.
Delegate Price.
Thank you.
Senator Mason,
Sir,
come on up.
Mr. Chairman, Senate Bill 1768 for me, Mr. Chairman.
1768.
Yes, sir, Mr. Chairman, I've never done one of these bills before, but one of the luxuries of living in Williamsburg is a lot of people come, bring their associations in town. When the gentleman from James City County isn't available, they get the B team for me to go speak to him. And the Highway Workers Association from across the country were meeting. And I went and spoke to them one morning, tell them where to spend their money in town. And they asked me a question: what's the most dangerous thing going on in a work zone across the country? And I said, excess speed. And they said, no, distracted driving. People using their phones and doing different things in the work zone while talking on the phone. So, as I said, you know the big policy. We've talked about that forever. I believe you have a bill, Mr. Chairman, on the topic. Mine's tailored just to not using your hands-free device. It says unlawful to operate a motor vehicle highway work zone while using any handheld personal communication device, and that's the bill, Mr. Chairman.
Charles, can I ask you a question? If this were passed, does it conflict with the substitute I intend to introduce? Just out of curiosity.
It does not, Mr. Chairman.
Okay, thank you. Any questions of the patron? You have anybody like to speak in
I
support?
don't think so, sir.
Anybody opposed to it?
You all know the drill.
I would move to report, sir.
Is there a second to that? Motion probably seconded to report the bill. Please open the roll. I'm sorry.
Mr. Chairman, there may be
Withdraw my motion.
this bill creates a new subsection B, so what the bill's unintended consequence, in which I don't think is the patron's intent, is that any person operating a motor vehicle on the highway who then enters the work zone would be in violation of this. So it changes the existing law so that if you're even talking on your phone, you'd be in a work zone, you'd be in violation of this new subsection B.
I think that's what he was after.
I mean, if you're on the phone in a work zone, yes, sir. I mean,
I was unsure if that was the patron's intent.
that's one of those, if you see it coming, Mr. Chairman, hey, I got to call you back.
Can I ask
Senator Sturdivant.
If I'm reading this right, this would also make it a Class 1 misdemeanor? Is it a Class 1 misdemeanor now, under current law?
No, Mr. Chairman, under the current law, it would be it's a $250 fine.
Right.
It's a year in jail, right?
Mr. Chair.
Mr. Chairman.
Senator Deeds was
If
next.
you're in a work zone and stopped by a flagman for 15 or 20 minutes, it's still, you still can't talk on the phone.
You're going to be Mr. Chairman, Senator Deeds, you're going to be a lonely man for a little while. Yes, sir.
Mr. Chairman, this would also include, I think, if you have your phone set for GPS directions, it's audibly getting me from Richmond to Williamsburg, for example, and I go through a work zone, I am using a handheld personal communications device.
It's very long and very sad.
I don't think the patron intends that.
Senator McDougal.
Mr. Chairman, I'm just playing off what Mr. Benjamin just said. If I had the wireless headset and the phone sitting on the back seat of my car and it rings, but it's in my ear, am I not using it?
Mr. Chairman, I think the senator is right.
Mr. Chair.
Using any Mr. Chairman, using any handheld personal device. Handheld.
Mr. Chairman,
Mr. Benjamin.
A handheld personal device describes the device. It could be
Right.
sitting on the seat and not be held in my hand and still be a handheld personal communications device.
Mr. Chair.
Senator Peterson.
That's a good one.
I would simply say, you know, we have general district court judges in this state that I think can figure this out. Handheld to me would mean holding it in your hand at the time you're using the device. I
Mr.
think
Chairman.
Actually, you're going to get to hear a bill that says just that. You can't hold it in your hand while you're operating a motor vehicle.
The amendment then, Mr. Chairman, would be while holding a handheld, or while holding a personal communications device.
Motion properly seconded to amend the bill as described. All in, you okay
good.
with that?
Yes,
All
sir.
in favor, please say aye.
He's right. That's good.
Aye, opposed, no. The ayes have it. All right, we want to work on it anymore, or you want to renew your motion now?
I'll move to report it as amended.
Thank you.
Motion properly seconded to report the bill as amended.
Mr. Chairman,
Please,
before
any
we
discussion
jump,
on
well,
that?
just before we jump through, is this highway work zone, is that the one we use other places, or is this?
Do we have it defined somewhere?
Is it, I mean, I guess it looks at line 54. Is that the traditional language we use? I haven't compared it.
Mr. Chairman, I believe that is relocating the existing language on lines 32 to 34 into a new definition. So highway work zone was defined under current law in this section, and just the stricken language is being moved to a new definitional part.
That's what we tried to do.
Do we need to revisit the motion, Senator McDougal?
No,
No.
if they say it's what we use other places, that's.
All right, motion properly before us. Please open the roll. Thank you, Senator Mason.
The non-lawyers in the family, thank you, Mr. Chairman. Thank you all, Mr.
That take care
As
of you?
11 knows 4.
Thank you.
Let's see, do we have, they're all in transportation, okay. I've got several witnesses here. Would you all, Tommy, would you do it? Senate Bill 1341.
All right, ladies and gentlemen of the committee, Senator Stewart has asked if I would preside. He has a bill that has some witnesses here that we would certainly like to accommodate. So if I could direct your attention to Senate Bill 1341, please. Yes, sir.
Thank you, Mr. Chairman. There is a substitute which Charles distributed.
Senator Reeves moves and Senator McDougal seconds that the amendment in the nature of substitute to Senate Bill 1341 be adopted. All in favor signify by saying aye. Aye. And the amendment in the nature of substitute is before us. Perhaps Senator Stewart, it'd be helpful if you could tell us what the substitute does that the original bill did not, sir.
Mr. Chairman, Senate Bill 1341 now takes us hands-free, but the language is very simple. If you look at it, it's unlawful for any person while driving a motor vehicle on the highway to hold a handheld personal communication device. And there are certain exceptions to that. Law enforcement and on duty, actually in the performance of their duty, the citizens band radio folks, and certain other ones over on page 2. We also have some enactment clauses which are designed to take some demographic data because there have been concerns expressed potentially about profiling. But it's a very simple bill. Mr. Chairman, I will tell you, I have resisted this for right many years, and I really resisted it because I believe in personal freedom, but it's gotten so bad. People are so totally engrossed in their phones that they absolutely are oblivious to the world around them. And it's to the point where these individuals are imposing on everyone else's freedom. And that's why I think the time is now to do this, despite the fact that I have resisted it in years. Certainly, you know, east of Richmond, you can't move. And half the time, it's because somebody's glued to this phone. You can't get through a traffic light in one cycle most of the time because people are buried in their phones. So that's what the bill does, and that's why I brought it. And there are those here
Senator
who
Stewart,
may like to speak.
your amendment, the nature of the substitute, has a delayed effective date. Is that correct, sir?
Yes, and that is to give us time to educate the public, to get some information out there because we don't want to catch people off guard on this. That's the main reason for it. I apologize. Thank you, Mr. Chairman.
Okay. Did you have any witnesses that wanted to testify, sir?
There are folks who'd like to speak in favor.
Mr. Chairman, Dylan Bishop on behalf of the Virginia Law Enforcement Sheriffs, and we support this bill.
Thank you very much for being here. Good afternoon, sir. How are you?
Good, Senator. Thank you for having us here today, and certainly thank you to Senator Stewart. I'm not sure I can say it any better than he's already said it. But however, just this opportunity, I'm Sheriff Steve Dempsey, King George County, and also currently president of the Virginia Sheriff Association. And on certainly sitting outside talking to Chief Doug Goodman, who's president of the Virginia Association Chief of Police, had to leave, so he's asked me to let you know that the Virginia Chiefs Association as well is supporting this bill. And certainly on behalf of Virginia Sheriff's Association, we sheriffs across the Commonwealth, we also support this bill. The current law as it is written, the texting law as it is just certainly unenforceable and a very difficult bill to get a conviction on. So in 2017, 4 officers nationwide were killed as a result of distracted drivers. In 2018, 6 officers died at the hands of distracted drivers. In the first month of 2019, 3 officers have already died as a result of distracted drivers. 39 years in law enforcement, driving under the influence of alcohol and drugs has always been one of our major threats on the highways, and we all know that and certainly remember those days. It still does create a major threat, but statistics now show that the cell phone distraction has created even a greater threat to the safety of our highways. Thank you very much.
Thank you very much for being with us, sir. Yes, sir, if you'll step right up. We'll like to hear from you very briefly in support, sir.
Mr. Chairman, I'm Michael Allen. I represent Drive Smart Virginia and the Virginia Safe Driving Coalition. We are in support of this bill. Traffic fatalities fell each year until 2013. Beginning in 2013, they have climbed each year since. This is in spite of new technologies making vehicles safer. In 2016 alone, there was a 10.8% increase in those fatalities. Quite frankly, in the past year, we've seen numerous incidents of police, fire and rescue who've been struck by distracted drivers. In the states that have enacted hands-free bills, we've seen a 16% decrease in fatalities in a 2-year period. And it is our hope that we enact this in Virginia and decrease fatalities.
Thank you for being
Thanks,
here
sir.
on behalf of Drive Smart. Yes, sir, very briefly. Thank you, sir.
Mr. Chairman, Bud Vi from Richmond Area Bicycling Association, and we strongly support the bill. We've just seen, most of our members, we have over 1,000 members, and most of them are members of AAA also. And you get the magazine, we just got the word in there that they had run a survey of their membership, found that 81% of the drivers who are members of AAA find that this is a serious problem. And of that 81%, 61% of them do it themselves. So we'd like to see this bill go through and give everybody a little bit of motivation to set down that cell phone and see who's around them. Thank you.
Thank you for being with us, sir. Yes, sir.
Mr. Chairman, members of the committee, Champ Early, President of the Virginia Bicycling Federation, we also strongly support this bill.
Thank you for being with us. Good afternoon, ma'am.
Good afternoon, Mr. Chairman, members of the committee. Kelly Suling with Geico, the #1 auto insurer in the Commonwealth. And we strongly support this bill for the reasons previously stated, and our policyholders' safety is our priority.
Nice to earn media there. Thank you for
Thank
being
you.
with us.
Hello.
about that.
Hey, how are you?
Mr. Chairman, members of committee, Vicki Harris with USAA. Number one, personal lines auto
I knew
insurance
this
across
was
the
coming.
United States.
I looked down that line and I knew what was coming.
And we strongly support the bill.
Thank you for being with us. Yes, sir, Mr. Patrick.
Yes, Mr. Chairman, Patrick Cushing with Williams Mullen on behalf of the AAA clubs in Virginia. It was mentioned that the polling that AAA does to our members, which is about over 1 million members in Virginia, the distracted driving is consistently a high poll rate in terms of responses, concerns from the public, or our members in particular, and the dangers associated with distracted driving. So we support the bill and urge your support.
Thank you for being with us. Yes, ma'am.
Hello, my name is Jennifer Smith. I'm the CEO of StopDistractions.org. We're a network of victims' families all across the country, and I work on this legislation across the nation. I just wanted to give you some comparable data for a state that has recently passed a similar law to get the phone out of the driver's hands, and that was in Georgia. With 6 months of having this law in effect, going into effect July 1st, they have shown a reduction of 7% in fatalities in the state, 102 lives saved in 2018. That was after a 34% increase in fatalities since 2014. We also have citations. The first half of the year without that legislation, only a texting law was 3,827 citations. After a 90-day grace, they were able to show 8,389 citations. It is enforceable without the loopholes and easy distinguish. And also, there is a 90% awareness of the law in the state and compliance. We also have TrueMotion telematics data that shows actual use by drivers while driving, their typing and swiping has gone down 22%, which has led to the reduction in crashes and fatalities. So
Thank you for joining us today. We appreciate it.
Mr. Chairman?
Senator McDougal, yes, sir.
I'm going to ask a legal question. Steve, maybe, do we define to hold, Senator Stewart? I love the fact that you switched this from operate to while driving, and many of us who are in court understand that operate means ignition on, you could be in your driveway. So thank you for doing that. But to hold, if you have it in your jacket pocket, is that holding it?
Holding's in your hand.
Well, that's what, Mr. Chairman, is that,
In your hand.
I mean, so I want to,
Mr. Chairman, I think.
Possession's in your jacket pocket.
I think Senator McDougal raises a valid point. It could be in your lap and you could be considered to be holding it.
So Senator Benjamin, with your insight
I think that's
on the fly, what would you propose?
A stretch. Mr. Chairman, I think that's a stretch. Possession is on your body, and we all know what possession is. We've all tried those cases. Holding is clearly in your hand. Now, I've heard people use holding as a slang term to say I'm holding a $20 bill or something in your pocket.
Mr. Chairman,
Holding is in your hand.
I'll note that one of our other offenses is carrying a concealed weapon.
It's not on my hand.
And you can be carrying a concealed weapon even if it is under your seat.
But that is the title of the statute. The body of the statute talks about on or about your person. It says carrying on or about your person, which defines carrying. Hold is hold is hold is hold, I think.
Mr. Chair.
Well, Senator Stewart, it is your bill, and the committee has it within its embracement. Senator Sturtevant?
Mr. Chairman, how would an Apple Watch be interpreted if an Apple Watch is on your wrist, it's on or about your person, are you holding it? And it can be used to text and send messages.
Yeah, hold it, Chief.
Personal communication.
Mr. Chair.
If you don't like the bill, don't vote for it, but don't try to find ways to make excuses to vote against it.
Mr. Chairman,
On or about your
Mr.
person
Chair.
is the concealed weapons statute that Mr. Benjamin just brought up, and it says carrying on or about your person. This bill says don't hold the phone while you're driving.
Mr. Chair.
That's what it says.
Senator Peterson, yes, sir.
I would simply say the use of the opposable thumb is typically how we define holding.
Are you going back to your caveman?
I'm going back to my roots. If it's some type of act that requires the use of the opposable thumb, which by the way is holding in the game of professional football. If you grab somebody's jersey, that's a hold. Having it in your lap is not holding, you're not using the opposable thumb.
Mr. Chairman, the solution, I think, would be
It's no-
to,
Sir-
the
yes, sir.
solution,
Mr. Benjamin, go ahead.
the
please,
solution,
sir.
Mr. Chairman, would be to insert in that person's hand, to hold in that person's hand a, I don't know then that you need a handheld, the word handheld, but look, Mr. Chairman, I will note that I daily work in the field of criminal defense, and these kinds of arguments and positions are in reality taken, and that's why this committee has always been good about being precise in its language. Senator McDougal did raise a very good point, so does Senator Peake, and that's why I suggested the language if the patron wishes it.
Mr. Chairman, I have the greatest respect for Mr. Benjamin. I just think that's not necessary
Well-
in this. It's to hold, and I would resist that amendment, quite
Okay,
frankly.
It is your bill, sir. All right. I think the
Oh, there may be opposition, Mr. Chairman. I don't know.
approach of the patron is pretty clear. Is there anyone in the audience that opposes the bill? The kind of day I've had, that is surprising, but
Second.
Thank you.
moved and seconded that the amendment in the nature of the substitute unamended to 1341 be reported. If you open the roll, sir.
Thank you, Mr. Chairman, members of the committee.
The bill is reported 13-2.
Thank you.
Yes, sir.
I know.
I've got one too.
All right, do we have patrons that still have bills? I'm sorry, members that have bills in the committee? We don't have any sort of sign-up sheet. Did you have one? No. Okay, well, Senator Deeds?
I think I have some witnesses too.
Senator Deeds, what's your bill number?
1484.
All right, 1484.
I think there's a substitute for it.
Would you please distribute the substitute? I'm sorry, if you told me, okay, we'll take you up next. All right, Senator McDougal moves and Senator House seconds adoption of substitute. All in favor, please say aye. Aye. Opposed, no. The ayes have it.
Okay, in a whole lot of sexual prosecutions that involve kids, the victim is not ready to come forward or does not come forward for some period of time. Well, often there are misdemeanor charges that could arise from that event, but the year statute of limitations has passed. So what this bill in substitute form says is that if the perpetrator is an adult, it lasts, the statute of limitations is there for 20 years. On a misdemeanor charge of a sexual nature. And I think there are some people here that want to speak to the bill.
Okay. Yes, ma'am, please come up.
Chairman, Senators, my name is Bethany Harrison. I'm the Commonwealth's Attorney for the City of Lynchburg, speaking on behalf of the Virginia Association of Commonwealth Attorneys in support of Senate Bill 1484 as it expands our ability to hold sex offenders accountable, specifically those who offend against children. Thank you.
Thank you. Yes, ma'am, please come up.
I'm Brittany Anderson on behalf of the Attorney General's Office, and we do support the bill. Delayed reporting is very common in sexual misconduct cases, and it's not until a victim has a change in circumstances such as therapy or living arrangements that victims feel comfortable coming forward to support. Oh, sorry, I'm very short. I do want to point out, this was a bill that was a recommendation from the Pennsylvania Grand Jury's report having to do with the clergy abuse. After that report was published, they had heard from 1,000 victims and heard evidence from a lot of people that had been victims of clergy abuse who were minors at the time and didn't come forward with that reporting until they were in their 40s, 50s, or 60s. And out of that report, the grand jury recommended a number of policy changes, and one of those was to extend the statute of limitations on sexual misconduct cases.
Yeah, I do. I'd like to ask her a question before she goes.
Yes, sir.
Senator Norman.
Mr. Chairman asked us a question in another committee recently, and I'm not trying to be antagonistic. Is the Attorney General's office monitoring all of the committee's meetings now or just selectively?
Thank you for that question. Our office reviews every bill that's filed with the General Assembly on behalf of the governor as our client and also on behalf of our client agencies and state agencies to look for any legal concerns with certain policies. We don't monitor committee dockets or certain committees. We obviously have a number of bills that are policy priorities for general hearing that we do work on. But we try not to take positions on bills unless it impacts the Attorney General's office. And any concerns we have with bills, we do try to work with patrons or with our client agencies to work through those.
Okay, Mr. Chairman.
Senator Norman.
You know what the next question is going to be then. How does this bill affect the policy of the Attorney General's office, or what are your articulated concerns with the amendment in the nature of the substitute?
We support the bill, and we actually asked for the amendment because we had some concerns had been brought to us about the way the bill was crafted. It may unintentionally capture minor on minor crime, so we tried to limit it to just instances where the abuser was an adult. Thank you.
Now, Mr. Chair, you may remember that this is very similar to a bill I carried about 3 years ago that passed this committee and did not get through the Finance Committee, I think. But it is, we're just talking about misdemeanor offenses.
Mr. Chairman. Senator McDougal.
Mr. Chairman, Senator Deeds.
Yes.
20 years, so that means somebody is 30, they could potentially be 37, 38 years old.
It could be, yes, sir.
Mr. Chairman, can you tell me, I know a couple situations where we have 5 years that we extend the statute of limitations for misdemeanors. Is there any other place in the code that we would extend it for this long?
I don't think so, and if 5 years will make this bill more palatable, I would be amenable to that. But frankly, with the nature of sexual offenses and the fact that a lot of these prosecutions for felonies don't come up for some period of time, more than 5 years after.
Mr. Chairman?
Senator McDougal.
Well, isn't the case that if it was a felonious offense, so if the individual was certainly below 16 years old, there would be no statute of limitations for that felonious event. So we're really talking about a smaller window of individuals.
And where I've seen this come up more often and where it's been brought to my attention more often is when felonies are alleged, and there are also misdemeanors that could be alleged along with that. And the misdemeanors certainly would factor into the prosecution, but they can't be brought because the statute of limitations is run on.
Mr. Chairman, at the appropriate
Senator
time,
McDougal.
I think there are half a dozen or so situations where we've set as a policy 5 years statute of limitations. I'd be okay with that.
Are you
at the
offering an
appropriate time.
amendment?
Well,
Amendment?
I don't want to move in front of anybody else, Mr. Chairman.
Okay.
Mr.
Any other
Chairman,
questions to the patron?
I do have a question that
Mr.
may be for
Benjamin.
the Attorney General's office. In order to effect the intent of the amendment on line 68, shouldn't the word is be was, requiring that the offender have been an adult at the time of the offense? I think the intent, Mr. Chairman, is that the defendant or the offender must have been an adult at the time of the offense.
Certainly.
And so I think it should be was instead of is.
I think it should be has been.
Are you offering any amendment? Are there any amendments anybody wants to offer?
I think on line 58, he wants to.
68.
68.
68.
Is, and the new language becomes was. Is that
That's what I'm suggesting.
Yeah, I think that's what he's.
Was an adult,
Does that
he's
make
correct.
sense?
All right,
Yes, Mr. Chairman.
Okay,
all right.
and I'll
Motion-
offer that amendment.
All right, motion properly seconded. Senator Peterson seconds it. To amend it to was on line 68. All in favor, please say aye. Aye, opposed, no. The ayes have it. Senator McDougal, do you have another amendment you want to offer? And I'm not suggesting it, just making sure we don't
His
pass over
amendment
you.
on line 69 would be 20 years to 5 years. Is that correct, Mr. Senator McDougal?
I don't know if they've made that amendment yet, Senator
Okay.
Deeds, or if he's offering it. 20 years is a long time. 20 years is a long time. Excuse me? Moved and seconded to amend the bill to strike 20 and put in 5 on line 69. Senator Deeds, you okay with that?
I'm okay with that.
All right. Motion properly seconded to amend it as described. All in favor, please say aye. Aye. Opposed, no. Ayes have it.
Then I'll move to report the bill as amended.
Second.
Motion properly seconded to report the bill. Do you want to amend your motion to re-refer to Senate Finance?
We're still talking about misdemeanors. Does it have to go to finance?
I got the chairman right here, says it needs to go to Finance, and we got a letter from Finance as
Okay.
well.
Okay. Amend it and go to report and re-refer then.
Motion properly seconded to report and re-refer the bill to Senate Finance. Please open the roll.
Ayes 14, noes 1.
Thank you, Senator Deeds. Senator Reeves, I understand you have witnesses that have been here. What's your bill? 1738. All right, 1738.
Okay.
Thank you, Mr. Chairman. 1738 is a bill that clarifies the existing code for prosecution of illegal gambling by specifically declaring illegal, so the so-called sham sweepstake machines. This bill is designed to make it easier for our law enforcement to go after and prosecute those type of machine establishments. It's a real problem for all of our charitable gaming, hold on one second, I'll get there, and bingo operators in Virginia, and I think Charles has an amendment in the nature of a substitute.
All right, would you please distribute that?
I'd move to substitute, Mr. Chairman.
All right, and Senator House seconds. The substitute be adopted. All in favor, please say aye. Aye, opposed, no. The ayes have it.
So, Mr. Chairman, this is a compromise bill that we've been working on for weeks on end, and thus Senator Cosgrove rolled his bill into this bill. Without his help, we probably couldn't have gotten here. So if we can, we've rolled his into ours. He listed as chief co-patron on it, I believe. Okay. There's no physical impact. It just merely clarifies existing law, and I do have some folks to testify as to the point.
All right, those that would like to speak in favor of the bill, please come up.
Thank you, Mr. Chairman, member of the committee. It's Chris Peterson. I'm here today on behalf of the Virginia Charitable Gaming Council. We're an organization that represents the various entities. With me today as well is the American Legion. We support this bill. The sweepstake games are really just illegal gaming. You purchase something and then you get to gamble because you purchased a vape or a pack of gum. They're not sweepstakes. They're actually illegal forms of gaming. We believe they impact the charitable gaming, tarnish our reputation, and we'd like to thank the senator for sponsoring this legislation. Thank you.
Yes, sir.
Chairman, thank you. Being involved with the American Legion, we use a lot of charitable gaming to raise money for our communities, to support children going back to school, giving them backpacks. And when we find our patrons that might attend a bingo game aren't coming because they're down at the sweepstakes spending their money there, we have worked with Commonwealth's attorneys asking them to please shut it down. We've found that they've kind of felt that their hands have been tied. So we hope this legislation would help them to be able to identify these sweepstakes and help shut them down.
Okay.
Mr. Chairman, I do have one line amendment for Senator Obenshain.
Can I ask you a question real quick about
Sure.
this? This wouldn't include like a box of cereal where you get a toy out of it?
A what?
This wouldn't include a box of cereal that you get a toy out of it, would it?
That's the amendment. No, Mr. Chairman.
Did you read it?
Mr. Chairman, that's what the amendment that we have will fix that. I know we talked about this 6 years ago, or whatever. Charles, you want to?
Mr. Chairman, got
Yes,
an
sir.
amendment to report. We call it the Happy Meal Amendment. So you don't get McDonald's sweepstakes, you don't get those things. the
Why don't you
cereal
tell us
box.
what that amendment is?
Amendment is, I think at the end of line 23, after the word value, insert, by means of the operation of a, quote, gambling device, end quote, as described in subdivision 3 of this section, period. And I think that takes care of it, Mr. Chairman.
Do you have that
Council
language,
would
Charles?
Yes, I do, Mr. Chairman.
All right, is there a motion on that amendment?
I move the amendment.
Motion properly seconded to adopt the amendment as described. All in favor, please say aye. Aye. Opposed, no. The ayes have it. All right, is there anybody here who'd like to speak in opposition to this? All right,
Move to report.
for the committee.
As amended.
This needs to be amended to be re-referred to Senate Finance.
No. Mr.
We
Chairman.
have a
if I-
letter on it. We have a letter on it.
If you have a letter,
Is
then.
that an amended, are you amending your motion to
I will
report the
amend
bill and
my
re-refer to
motion
Senate
to re-refer
Finance?
to finance.
Okay.
Yeah.
And we
Mr.
have a
Chairman,
second on that?
speaking to the motion?
No.
No.
Just let it go.
Let
No,
it go.
sir.
Thank you, sir.
Clerk, please open the roll.
Look at Mr. P. Thank you. Appreciate it.
Ayes 15, no zero.
All right, any other, Senator Peterson?
Mr. Chair, ladies and gentlemen of the Senate, this is Senate Bill 1399.
1399.
And I'll give you a heads up, it may be a bit controversial. It is the bill on corporal punishment. And let me just preface by way of saying it was brought to me by a family law attorney in Fairfax County. He was a good friend of mine. She went to law school with me, who really works in this space and basically has dealt with situations where children have been subject to corporal punishment, specifically with a foreign object. So this only deals with that punishment which occurs with an object, you know, whether you'd say foreign object or inanimate object. I talked with Mr. Benjamin about that. But simply, this would take that situation and where it was brought to the attention of the Commonwealth, it would only be a class 4 misdemeanor. It would be a mandatory deferral, just like we do with marijuana possession. So it would not be something that would be on the permanent record. But basically, the point would be that you would try and get that parent into a parenting class. And again, we're dealing with situations where someone's using a rod, a switch, a belt, something along those lines. And let me preface by saying, because I know the questions I'm going to get, I grew up like everybody else did. I was spanked with pretty much every object in the household, okay? And I spanked my children all the way up until number 4, and then I stopped. And that was reasons that had to do with that child specifically. But the bottom line is, I have come to, as a parent, come to realize that there's a time and a place sometimes for, you know, being physical with the kids, but the bottom line is using a foreign object or an inanimate object is not right. And I have carve-outs in this bill for situations where there's self-defense, because I realize that happens sometimes, unfortunately. But the bottom line is, I'm not looking to trap parents, but hopefully this would be a law that might help become better parents. So I stand here ready for the questions, but that is the purpose of the bill.
Any questions of the patron? No
Mr. Chairman.
questions. Senator Howe.
So a parent could still wallop the kid with his hand.
Well, you could be, yes, I mean, they could be
Okay.
subject to
So you could still
child
spank.
abuse. You can still spank. It's a foreign object.
Right. Just want to make sure that's
Right.
clear.
Or
Mr.
slap or
Chairman,
whatever.
Mr. Chairman, to ensure that, on line 16, I suggest inserting the word inanimate before the word object.
Not kidding. I'm taking a football. Only one of my boys.
I'll move that amendment, and I think I'm holding somebody's proxy, maybe Edwards. So I'll move that amendment.
Is there a second to that amendment?
Edwards seconds.
To make
Inanimate.
it inanimate object instead of just object, so that you could use your hand still. Motion properly seconded to amend it as described. All in favor, please say aye.
Aye.
Opposed, no. The ayes have it.
Mr. Chairman.
Senator Chafin.
Yes, sir.
Senator Peterson, so maybe one of the most time-honored objects to use is a switch, okay?
Yes, sir.
Cutting a switch. There's all kinds of writings about it. Cutting a switch from a tree, taking a switch, and swatting a child. That would be a violation of the statute, am I right?
Yes, sir.
Anything would be. I mean, anything.
Yes, it would be an object, yes.
Anything, okay.
So nobody could see it. Senator Sturdivant?
Senator Peterson, if this is not just a parent, but this is other person responsible for the care of the child under 18 years of age.
Right.
So, and this is the context that Senator Reeves pointed out, is if you're at football practice and the football coach hits you on the helmet with his whistle or something like that, because you screwed something up, and he is disciplining you for having screwed something up on the field, that's an inanimate object. Is that
Let me
a
tell you.
class 4 misdemeanor?
I've coached football. I've been USATF football certified. I've gone to every single coaching clinic. If I struck a player with a whistle, I would lose that position in a heartbeat.
On the helmet?
In a heartbeat.
Interesting, yeah.
In a heartbeat. You're not going to coach if you're hitting your players with a whistle or anything else. I mean, I would not, anyways, I wouldn't do that.
Mr. Chairman,
Senator McDougal?
just, I know it's late here, and so I'm not going through this quite as quickly as I would like, but the infliction of or causing the infliction of physical pain, does this require an actual physical touching of the child?
Well,
I mean, because Mr. Chairman, it says who uses an object to subject the child to corporal punishment, which corporal punishment is not defined as a touching. So if you said you have to be, you have to run the stairs, that's going to cause them physical pain. We're not actually requiring a physical touching to get to the pain. It just says causing. It's done, I mean, again, it's a little late, but I don't see any requirement of a touching.
Means the infliction of or causing physical pain, uses an inanimate object.
To subject.
Well, I'm not quite sure under your scenario what the inanimate object would be.
The bleachers.
Well, I don't think fatigue and physical pain are necessarily the same thing, but, look,
As a means of discipline, I think it does. Does it require touching? Steve, there's no touching required.
No, touching is not required, Mr. Chairman. Senator McDougal.
Mr. Chairman, I'd love to.
You have a motion on this
I
bill?
do, to gently PBI, let Senator Peterson work on finding a way that a touching would actually be required in this.
Hold
for
that
next year.
motion for just one
Okay.
second. Senator Norman?
Senator Peterson.
Yes, sir.
I'm not trifling with you. How about, my wife and I decide we're going down to the disco to dance one night, and so we leave our 18-year-old son as the caretaker or the babysitter for our 14-year-old daughter. Is that going to
well,
subject that 18-year-old?
responsible for the care of a child under 18, so the babysitter would be.
But it's our child.
Brother.
Okay.
All right. Senator McDougal, you had a motion. Is there a second to that? Motion properly seconded to pass the bill by indefinitely. Please open the roll.
Ayes 10, noes 5.
Thank you, Senator.
Yes, sir, thank you.
Anyone else have okay, we've got other patrons out here. Senator Favoli, you're first.
Thank you, Mr. Chairman. My bill is 1092, and we do have some amended language, so.
Senate Bill 1092. Let's
Yes, you
get the
would be
bill
calling
before
it
us first.
an amendment in the nature of a substitute, I believe.
Why Why don't you tell us what it does, and then we can talk about amendments.
Okay, and I can even tell you what the amendment does. This is very straightforward. It came to me out of my work on the Sexual Assault Advisory Committee. And one of our folks that works with survivors in the Commonwealth Attorney's Office suggested this bill. Anyways, what it does is when a petitioner asks for a preliminary protective order, the full hearing for that protective order is usually 15 days after. That's current law. What my bill says is the hearing can be delayed, so the petitioner only has to come back once when they're actually doing the court trial, unless, and this is my amended language, unless the respondent makes a case to the judge that we need to do it within the 15 days or even sooner. There could be a respondent who believes, I'll use he or she in this case, but who believes that, you know, he has reasons, family reasons or child-related reasons or custody-related reasons that he does not believe the preliminary protective order should be in place beyond the 15 days.
So you want to ask for an amendment where?
The amendment.
Do you have language, or does Charles have language?
Mr. Chairman, I have language. It's on line 83. It's after the hearing in the first instance, because the hearing appears multiple times in that line. Insert the language or set a sooner hearing date. And then such amendment would also be need to made on line 162, again, after the hearing, and it would be the same language, or set a sooner hearing date.
And this was recommended to us by the Virginia Supreme Court policy people.
All right, Senator Howell moves the amendment. Senator Norman seconds. All in favor, please say aye. Aye. Opposed, no. The ayes have it. All right, any questions of the patron?
Mr. Chairman.
Senator McDougal.
Just logistically, this does happen a lot, but usually that's because an agreement, a person that's subjected to a protective order asks for it to be continued, and everybody, and the Commonwealth's attorney is involved in that process, and the court grants the motion to do it. But if somebody wants to, even if there's a criminal offense, if somebody wants to go forward on their hearing for protective order, why shouldn't they be able to do that in the 15 days?
Well, they could with my amended language. The respondent would just have to make the case to the judge that there's a reason that the hearing should take place sooner. It's that 1% of the time, which is what you're referring to, that the Supreme Court policy person was telling us. Most times, the respondent doesn't even show up when the preliminary protective order hearing is granted, most times. And then within, you know, we were trying to make it so the petitioner wouldn't have to come back too often. So we wanted the petitioner to come back at the time that the criminal case was heard or the court case was heard.
But Senator Favola,
but we did allow that carve out.
Can't the petitioner get this on an affidavit?
Well, I was
any hearing at all?
I was advised that initially they could get it on an affidavit, and then the hearing has to be held, though, within 15 days.
Unless the full protective order, okay. Senator McDougal, you finish, I interrupted you. Senator Chafin.
Senator Favola, I mean, this is, in the sense that this gives the petitioner the right to move the date, that's a sea change as opposed to the respondent asking for it. Would you agree?
Well, I wouldn't call it a sea change. I mean, we're leaving the 15 days there. We're just, I don't think it's a sea change. We're just trying to make it more efficient. I think this actually makes it efficient if you're talking about the petitioner not having to come back and petitioning the court to extend the preliminary protective order after 15 days and then coming back again because the criminal trial is later than the 15 days. We were trying to relieve the burden on the petitioner, and we then had a carve out for the respondent.
Well, Mr. Chairman?
I don't consider it a sea change, but maybe you do.
Wouldn't you agree that if the petitioner wants to delay, I mean, if they want to put it off, okay, for whatever reason, maybe to clean out the house, maybe to do all the things that people that practice law see people do in the real world. This gives them the opportunity to have a protective order extended, perhaps even for months without a hearing.
Well, the judge makes the determination on, I believe, on when the criminal case would be heard. So it's not the petitioner asking for a date certain. The petitioner's merely saying, I'd like to have the opportunity at the time the criminal case is heard to also hear the case on extending the protective order. But the court is determining when the hearing will take place. So I don't think
Mr.
it's a
Chairman,
sea change.
oh, I'm sorry. When, Senator Chafin, were you through? I'm sorry, didn't mean
Senator
to interrupt. Senator Favola, and I actually do some of these things. And the problem is the court, you don't talk to the judge. You talk to the clerk who has a certain amount of dates, but then you also have the petitioner's attorney and who you have these domestic events. And so you can look at three, and their attorney will be involved in the protective order, can be. And so you're then looking at 3, 4 months down the road, depending on the jurisdiction, how many judges they have, when they set these things.
Well,
The problem, the sea change on the protective order is that it's, the petitioner goes in, it's her only uncontradicted testimony, and then the respondent is under the protective order, and if you take out that 15 days, until they get a trial date on the assault and battery, which is what it usually is.
That's why we have the carve-out, because the Supreme Court doesn't like sea changes, so they asked for the carve-out.
Which is?
Which is, or set a sooner hearing date if the respondent wishes.
Mr. Chairman, the problem is that with them or their lawyer, you cannot get, and the court's schedule, you cannot get a sooner hearing. And that's my problem with the bill, Mr. Chairman.
Well, okay, there may be an implementation issue, I don't know.
All right, Senator Favola, do you have anybody who'd like to speak in favor of this?
No, but I'll just be glad if nobody opposes it.
Is there anybody who would like to speak in opposition? All right, if there are no questions, the bill is before us.
It's a good bill.
All right, we got competing motions. Is there a second to either of them? We got a motion to PBI and a motion to report. Is anybody going to second either motion?
Second motion to PBI.
All right, we've got a motion properly seconded to pass the bill by indefinitely. Please open the roll.
Ayes 9, noes 5.
Mr. Saslow, I
Maybe
didn't
next
leave his
year.
proxy. Okay.
Thank you, Senator
We're
Favola.
coming back. Thank you.
Senator McClellan.
I am going to do Senate Bill 1437 first, because I
Senate
think
Bill
I have some
1437.
folks that have been waiting to talk to that bill.
I have no idea.
Senate Bill 1437 deals with the fishback issue, which I know the members of the committee are familiar with. It's a little bit different than the bill I had last year. These are the individuals who were convicted and sentenced after we abolished parole, but before the Supreme Court in the Fishback case ruled that juries should have been notified that parole was not an option. And so last year I had a bill that would have made those individuals that fall in that window eligible for a new sentencing hearing. There were a number of concerns raised by the committee about having a sentencing hearing so far after the fact. In talking to some people who expressed opposition to that, they said they actually trusted the parole board more than they would a new jury. And so this bill makes those individuals eligible for parole and leaves the decision to the parole board.
Is this the same bill as last year,
No.
Senator McClellan?
No,
You made
last year's
changes?
bill would have made them eligible for a new sentencing hearing.
Okay.
This bill makes them eligible for parole so that now the parole board
Can make the decision.
can make the decision
Okay.
and not a new
I apologize.
jury.
I had someone else talking to me while you were talking.
That's okay. I think there are some folks who are here in support of it.
Well, please have them come up.
Oh, I don't want to start yet.
Yeah, good
Thank you, and
afternoon.
we do time each side to 3 minutes on for the folks who want it and the folks who oppose it. So
okay.
just so everybody knows. If you want to speak in favor, please step up.
All right, okay. Oh, gosh, okay. Well, I would say good afternoon, but I think it's good evening now, okay. First of all, I want to thank you, Senator Jennifer McKellen, for sponsoring 1437, parole eligibility for those on the fishback. And I want to thank you all to the committee for allowing us to come in here into your house to speak for the people. So, my name is Lily Branch Kennedy, and I'm the executive, and I'm here standing here as the executive director and on behalf of the nonprofit Resource Information Help for the Disadvantaged and Disenfranchised, RIHD, and its 4,700 plus Virginia membership in support of Senate Bill 1437, parole eligibility to incarcerated defendants. Whereas the jury were not instructed on the abolish of parole at or during the sentencing phase from January 1st, 1995 to June 9th, 2000. Whereas incarcerated defendant Richard Fishback filed and won in the Virginia Appellate Court a new and fair sentence. Fishback versus Commonwealth of Virginia Appellate Court stated, it simply defined reason not to give jurors the information that parole was abolished. It also stated that instructing jury who will impose a sentence that parole has been abolished would ensure a fair trial for both the offender and the Commonwealth. RIHD supports 1437 parole eligibility because it is not merely a release, but a managed release with therapeutic programs, rules, and requirements that must be made that includes professional parole and reentry oversight. We support parole to lower the cost of incarceration and redirect some of those funds where it's most needed, such as increased prevention, deterrence, and reentry programs. On behalf of over 4,700 RIHD members that are constituents, concerned citizens, directly and indirectly impacted, and their families, collectively and respectfully agree Senate Bill 1347 parole eligibility would fairly remedy defendants and the Commonwealth. We ask that you vote yea for Senate Bill 1343. Thank you so much.
Thank you. And there are a lot of folks who would like to register their support. I would just ask you to state who you are, who you represent, and that you support the bill because we're out of time. But I want to let everybody recognize their support for the bill.
Good evening. Being respecter of time, my name's Kimba Smith. I'm a formerly incarcerated person. I was sentenced to 24 and a half years as a first-time nonviolent drug offender, and my sentence was commuted after serving 6.5 years. I commend all the family that's here in the room. I just ask that I support the bill, and I just ask that you all value lives. And it's not like in passing this bill that people are going to be freed. There's still a parole board that will evaluate if these people are capable of coming out. But there are people that are fully capable, like I've been, to be productive citizens and help encourage young people not to go down the same path and to live successful and be good citizens of the state of Virginia. And there's a family member here that's been impacted.
Thank you again. If you wanted to tell us who you are and register your support.
Yes, Chairman. My name is Kendall Churchill, and my brother was convicted April the 1st, 1996. He was sentenced to 96 years, and I do have the transcript where he falls under the Fishback law, where the judge did tell the jury that they were not to be concerned with parole. We have spent thousands and thousands of dollars, and I appreciate the opportunity to stand before you to ask that you consider the bill so that he can have a chance at parole. He has been rehabilitated. He has asked for forgiveness. He has even trying to think of the word, he has put together programs that they are actually using in the prison system as of right now. He's been in honors dorms. He has proven himself worthy of parole, and I ask that you vote yes.
Thank you. And again, we just have time if you want to say who you are and that you support the bill, because we've run way over.
Right, I'm
Sorry.
Lynn Dillon from Danville, Virginia. I moved here from Martinsville, to Mechanicsville, and I support the bill. My daughter was here.
Thank you.
We've got letters of support. She teaches, and she had to go back to class, but she was here for about 4 hours.
Thank you. I'm sorry.
That's okay.
We called Senator McClellan first, but she wasn't here. Yes, ma'am. Did you want to register your support?
Yes, my name is Reverend Rosalind Hall, and I'm an ordained minister. I was paroled in 1979. I've been 40 years successful, and I do support the bill.
Thank you.
Good evening. How you doing? My name
Good
is
evening.
Selima Kennedy. I'm here to support the bill. I'm here on behalf of my husband, Dawood Kennedy. Currently has 33 years to serve.
Thank you.
Thank you. I appreciate it. Have a good one.
Yes, ma'am.
Hi, my name is Carrie Anderson, and I support this bill.
Thank you.
Hi, my name is Rena Wilson from Chesterfield County, and I support this bill.
Thank you.
Thank you.
Hi, my name is Shantice Burnett out of Richmond, and I support this bill.
Thank you.
How you doing, Chairman? My name is
Good. How
Willie
are
X.
you?
Brown, and I support this bill.
Thank you.
How you doing, Mr. Chair? My name is Shaquille Ali. I definitely support this bill. And real quick, I know we're pressed for time. One of the main things we should really understand is that these individuals, the majority of them was not sentenced to death. And many, because of the amount of time they have, will die in prison. So we definitely have to take it into consideration. Thank you.
Thank you.
Thank you, and
All
I
right, Senator
apologize.
McClellan,
I
was
think
that-
I was in transportation when you
That's
called me,
okay.
so.
We knew you had witnesses, so we were trying to call you up early.
Thank you.
If there's no one else that wishes to speak in support, is there anybody in opposition? I don't suppose there are. Come on up, Ms. Jenkins. Fishback. Yes, ma'am.
Jenkins, Commonwealth's Attorney in the City of Fredericksburg. On behalf of the Virginia Association of Commonwealth's Attorneys, we oppose the bill. Couple reasons. One, Fishback specifically says that it is not retroactive in effect. And two,
Let's do the witness.
it will be difficult for a parole board many years after the incident has occurred to actually understand the gravity of what did happen. So it's a second look at a case where when it was fresh, there was the fact finder and victims were there, witnesses were there. Frankly, this is not a victim-friendly bill. And we believe, I guess last year, the number was placed at 10, the number of people who would be affected, because it would be people who had a jury trial and who were not, the jury was not instructed that there was no parole. I don't know if you can find out who those people are. I don't know how we can prove that, but because of the impact on victims, they've been told that they'll get out in 85% of the time. To change in midstream in this way is just, we have to oppose it.
Okay, thank you. Anyone else that'd like to speak in opposition? Did you wish to speak, ma'am?
Yes, Chairman, my name is Adrienne Bannon. I'm the chairwoman of the Virginia Parole Board, and I was here to state that the governor's position is that he strongly supports this bill,
Okay.
and also to address any concerns with regards to victims, and also the manner in which we review our parole cases. And just to let the committee know, we do have a victim services coordinator. We take our victims very seriously and thoroughly investigate our cases as well. And we believe that the parole board is best suited to address this systematic injustice that's addressed in the Commonwealth versus Fishback v. Commonwealth case.
We appreciate
Thank
you coming and testifying.
Thank you.
Okay, if there are no other witnesses, any questions of the patron? If not, is there a motion?
There's a motion properly seconded to report the bill. Would this one, if it were to report, go to finance? No. Okay, motion properly seconded to report the bill. Please open the roll. Lord have mercy.
Ayes 7, noes 8.
All right, Senator McClellan, you have another one?
I do.
you
Senate
wanna
Bill
take over?
1107.
Senate Bill 1107.
So this strikes subsection C from the disorderly conduct provision. Section C is the provision that deals with behaviors that occur on a school grounds or at a school-sponsored event. And the reason for this bill is Virginia leads the nation in referring kids to law enforcement for behaviors that at one time were handled through the disciplinary process. And disproportionately, we are impacting students with disabilities because a lot of the behaviors that they are being referred to law enforcement under this statute for are things like, and these are real examples, real cases. A student from Henrico who was, and they were only, these examples I'm giving you are students who were only charged with disorderly conduct under Section C. There was a kid from Henrico who was singing a rap song on the school bus. A kid in the city of Richmond who was running with scissors in the hallway. A kid from Hampton with mental health needs who was running through the cafeteria and shouting. A kid who moved into the school division, this is also Hampton. He was a bus rider. He tried to get on the bus. A teacher thought he wasn't supposed to get on the bus and blocked him, so he pushed past her. 3 cases in Danville of kids, a kid swearing at a teacher, a kid who cut in line, and one who was hit by another kid and struck back. In Roanoke, a 13-year-old girl, young black girl who was yelling at the parent of a white child. The parent got out of the car, put her in a chokehold. The parent was charged with assault and battery, and the girl was charged with disorderly conduct. In Lynchburg, 3 separate situations where students with mental health needs were flailing, and because they couldn't handle a schedule change, and they were put in handcuffs, and they were charged with disorderly conduct, and one was charged with assault and battery of an officer. A kid in Norfolk who was yelling profanities at another student and was charged with disorderly conduct. A lot of these behaviors, when we were in school, were handled through the discipline process. But what we're seeing now is an increase in the number of kids who are being referred to law enforcement under this charge for behaviors that really aren't crimes. And disorderly conduct, it is so vague and subjective that we think that this is really criminalizing childhood behaviors that should not be criminalized. And for most of, when there's been opposition to bills similar to this, most of the instances that opponents use to say this is why we need disorderly conduct, there are other statutes that you could charge that child with, other things you could refer them to law enforcement with. We don't really need this provision anymore.
All right, Senator Sasslaw.
Yeah, several years ago, we were presented with statistics. We were presented with statistics where there were like 2,500, 3,000 kids, 3rd grade and under, that were kicked out of school. That is just unbelievable. And when you and I, well, and me anyway, when I was in school, I mean, get in the closet and shut up, or go see the principal, and the principal would kick you in the rear end, tell you get back up class and keep your mouth shut, and that was the end of it. Now, if you look cross-eyed at the teacher, they call the cops. I mean, it's just gotten totally out of hand, and bills like this are needed.
Well, now that the patron has explained her intentions, Steve, do you think this accomplishes that? You see any issues this raises?
My concern, Mr. Chairman, is that
at least some of us believe that a school is a public building or public place. And so I don't think that the bill accomplishes what the patron seeks. That's number one. Number two, the patron referred correctly to students being referred or charged with disorderly conduct when other sections of the criminal code might apply. If that's the case, referring to line 31, you'll see that the current language provides that disorderly conduct does not include conduct that is otherwise made punishable.
That's not exactly what I said.
Sorry, I misheard you then.
Okay, what I said was the incidents the examples that I gave were kids that were charged under C. The point I was making is usually when there's been opposition to a bill like that, the examples the opponents use as here's an incident that occurred that, you know, if this bill passes, we wouldn't be able to do anything. And my rebuttal anticipating some of that today is most of those examples you're going to hear there's something else you could charge them with.
Understood.
I only focused on examples that were charged simply under C.
Then Mr. Chairman, I would ask the patron about the problem of a school being a public building or a public place. And if it, so the question, Mr. Chairman, would be, isn't a school a public place or a public building?
But here's the difference. In A, dealing with a public place, and as part of it, we sort of make clear that A would apply to a public place. The conduct has to have a direct tendency to cause acts of violence by the person that engages in that act. C, though, says
Disrupts the operation.
you disrupt the operation of the school, or I think it also...
Or any activity.
Yeah, so it's a lot more subjective than, and I can understand if you do something in a public place that could, you know, incite violence, that's different. But if you're just annoying a teacher or you know, if a cell phone goes off, someone could say, well, that's disrupting the class. That shouldn't be criminalized.
Mr. Chairman, I think that as the patron explains it, the bill does accomplish what she seeks, understanding that a student could still be charged with disorderly conduct if they engaged in conduct that created the risk of violence.
Correct.
Okay, then I'm fine with it.
All right. Anybody have any questions of the patron? Anybody here in opposition to the bill? All right. All right, there's a motion. Is there a second? Second. It's been moved and seconded the bill be reported. Senator Sturdivant, you got, all right.
Ayes 14, no zero, one abstention.
All right.
Thank you, Mr.
Senator
Chair.
Suderline, you're up next. I'm sorry, you have another bill?
No, I'm done.
Okay, Senator Suderline, 1764. I'm just looking at the sign-up list. That's the order, I'm sorry. Senator Suderline.
Mr. Chairman, Senate Bill 1764 is a bill that came at the request of folks in Farmville. This is something that Senator Peak's constituents were very interested in. There seem to be some folks that aren't thrilled with the bill, at least in its current form, and they talked to Senator Peak, but I didn't hear from them, and they're not here to speak against it. So I don't know if you want to go forward with the bill today, which...
I believe it's either going to live or die today.
All right, Senator Suderline doesn't want it. Can we?
Senator Peak? All right, well, you want to present the bill, or
No,
you want to
can present the
suspend
bill.
and let Senator Barker go, who has
Yeah,
been
you can let
sitting
Senator
there
Barker go right now.
with his support network behind him? All right. Without objection, I'll go by temporarily. Senator Barker, what did we not get to of yours while I was gone for 2 hours?
While I was upstairs with you for much of that.
Oh, yes, you were, weren't you? You didn't help me very much.
We'll get something figured out, so. I
All
have
right.
two bills, Senate Bill 1626 and Senate Bill 1627. These deal with an issue that received some prominence this past year in that there was a national report that cited Virginia as having a very high rate of evictions from rental properties. And I'm on the Housing Commission, and the Housing Commission spent a considerable amount of time dealing with this, had 6 bills, 4 of which have passed out of the Senate. The other 2 are these 2, which I'm carrying.
So these 2 bills come unanimously from the Housing Commission?
Yes, yes.
Are you aware of any opposition to these bills?
I'm not aware of any
Anybody
opposition
here in opposition to Senate Bill 1626?
We do have a small amendment on 1626.
All right.
Yes, Mr. Chairman,
Kristen?
1626 on line 38, after 5th day of each month, strike, or if the 5th day falls on a day when the court is closed the next business day thereafter. That language was holdover from a previous draft where the court was being paid instead of the plaintiff, so it's no longer relevant.
All right, Senator Stewart moves, Senator Chafin seconds that amendment. All in favor of that amendment signify by saying aye. Aye. All opposed? That amendment is made. Nobody here in opposition to the bill? Is there a motion?
Move the report as amended.
It's been moved and seconded the bill be reported as amended. The roll is open.
Ayes 15-0.
The bill reports. Next, we have 1627,
1627, which deals
also
with
a
termination.
unanimous recommendation from the Housing Commission.
Yes, and Senator
Anybody-
Stanley is my attorney if need be. since he
You
was
aware
on
of
the
anybody in opposition to the bill?
You have the right to remain silent.
Anybody here in opposition to the bill? Senator Stanley moves
Yes.
that the bill be reported. Is there a second? Kristen, no problems here? All right, it's been moved and seconded. The roll is open.
Ayes
All right.
15-0.
The bill reports.
Thank
Thank
you
you
very
very much. Senator Suderline, you ready?
I'm ready.
Yes.
Senate Bill 1764 seeks to address emergency custody orders. When a temporary detention order is eventually issued, there's often the lag time that everyone's aware of for the appropriate sheriff's office to respond and take custody of the individual. Currently, the code provides that the person shall remain in custody until a temporary detention order is issued, until the person is released, or until the emergency custody order expires. As you all are aware, that's 8 hours from the time of execution. This bill seeks to change the word issued to serve and would clarify that law enforcement has the authority to continue to hold a person subject to an ECO/TDO in custody between the time the order is issued and when it's actually served by the transporting agency. I think it's a good policy. It's something that came from the folks in Farmville, especially concerned about. The bill was filed 2 weeks ago, and now while I was in Senate Transportation, I hear that the folks that have concerns about it, who weren't for some reason able to find me for the last 2 weeks, asked that it be continued to next year. And someone else said that they were willing to do that.
Okay.
I think it's a good policy. I think it's something the Commonwealth ought to do. You all like the idea. I hope you'll advance it. You can either advance it to the floor or you can advance it to finance. So you give them a chance to hear it again, even though finance has so much on their plate.
Yeah.
But I think that
Okay.
they had 2 weeks to come find me. And one of the people they want to talk to is one of the members of this committee. So, I don't know why they're not here during the General Assembly session.
Mr.
Let's
Chairman.
talk, just.
Mr. Chairman.
Senator Peake.
This is my bill, Mr. Chairman, brought on behalf of Farmville. I was at my limit of 25. So I talked to the folks of Farmville who have talked to Senator Deeds. The mental health folks were here. The sheriffs were concerned, and the mental health concern, if this bill was going to do what we wanted it to do, which was the Farmville police were having to stay, they were concerned about how long they were gonna have to stay, so they changed the word from issued to serve. The question is what effect that'll have, but I told them all to leave, that we would move it. And Senator Suderline don't wanna mess up his record. This is my
Chair,
bill. Yes, Senator
Mr.
Steve.
Chair, it's
Now,
a very
Senator
real,
Deeds.
it's a very real problem, because sometimes the,
Yes, microphone, please.
Senator Deeds.
sometimes the TDO is there, you run out of time and before the thing is issued. The question was whether this legislation accomplished the goal. Now, while I was running between here and courts and the subcommittee upstairs, I understood that some people from the Department of Behavioral Health were here, and they were telling me what was going to happen with what the discussions were, but I've not actually sat in a room with people and talked about it.
Well-
It's a real issue.
Now that, I don't want to put you on the spot, but my notes here indicate that this bill and this issue was considered by the Deeds Commission and that it was not adopted.
There was, this problem was considered. We just weren't able to come up with a direct solution to it. And a lot of law enforcement are going to be opposed to anything that's going to require them to stick around longer than the 8 hours.
Or until the committee hearing.
And, Mr. Chairman, yeah.
I mean,
Senator Peake.
And that is, this was not concern about the staying, this was concern about the liability for the police as to whether or not they can contain the person while it's only been issued but not served. This is clearing them up so that they could contain it. The problem is what effect this language would have. And
All right.
that's the question. When is the next finance meeting?
Senator Peake, given that this is, as you say, your bill, even though it's actually Senator Suderline's bill, do you have a motion you want to make?
Can we refer this to finance and let us talk a little more?
Nope.
All right. Then I don't have any other
Finance
motions.
is not going to take it up.
Yeah. I told him I can't do that. I told that we
Senator
were not
Deeds,
going
do you have a
to.
motion?
I'll move to report the bill.
Is there a second? All right, it's been moved and seconded that the bill
good
be reported. Any
think
further discussion?
I think it is too.
The roll is open.
I'm going to vote no.
We're gonna give anybody who wants to raise concerns about this an opportunity to see that it's on the contested calendar. Come talk to Senator Suderline. It would be my hope that they would talk to him before they talk to any other member of the committee, and we can see where it goes from there.
That's the most abstentions I've ever seen in my years here.
All right, the bill reports barely.
thank you, Senator.
We
Deeds and
have
Senator Ovich.
we have Senator Edwards. Is he coming or not? All right, our Delegate Leftwich had forgery bill, House Bill, what? 1751. This is close to Senator Cosgrove's bill. Would be my recommendation that we conform to Senator Cosgrove's bill and report this. It's been moved and seconded that Delegate Leftwich's bill be conformed and reported. The roll is open. Then we have the deposition bill, which is part one of the trial lawyers and Chamber of Commerce deal. It is House Bill 2167, which reported out of here, I believe unanimously, and there were 5 no votes on the floor. Is there a motion to report that bill?
Is it identical to Senator Vogel?
It is identical to Senator. It's moved Is there a second? Moved and seconded to report the bill. The roll is open. And finally, we have Delegate Gilbert's bill 2197, which is the summary judgment bill, which is in identical form. It's been moved. Is there a second?
Substitute motion, I withdraw the motion. I withdraw the motion.
Is there a second, Senator Sasslaw? It's been moved and seconded that that bill be reported.
Ayes 7, no 6.
Squeaks out. And Senator Edwards had,
I could have killed that with Tommy's promise.
all right, Senator Edwards had, and he has 1309, which is identical to a bill that was heard last year that was defeated on a continued on a 10-5 vote. This is the last Senate bill before the Courts Committee. Unless there has been a substantial change of heart, that would be an appropriate motion. If there are a couple of no votes, it will still be within the breast of the committee. And if Senator Edwards has a strong desire to have it brought back, I'm sure that the committee will extend him that courtesy. All right, motion properly seconded to pass the bill by indefinitely.
2 noes.
All right. With that, the committee
Ayes
will
11,
rise.
noes 2.
The committee will rise.